Is your premarital house that you had before you married a marital asset if you get divorced? That's a question that we get all the time. Hopefully, you're asking that question before you get married so you can protect yourself if needed. Best thing is as long as you keep the property in your own name, it will remain a premarital asset. However, unless you have a prenuptial agreement, the increase in value of that premarital property or any other property that you have before you get married, the increase during the marriage is going to become a marital asset. So, for example, if you own a home, that's $500,000 when you get married, and at the time you separate, it's worth 600,000. The marital portion is that increase, which is 100,000. That's assuming there's no debt on the property. You also have to look at the equity. So you're looking at what was the mortgage balance at the time, because you could have a $500,000 home and have no equity if you have a $500,000 mortgage. And then when you separate and it's 600,000 and that mortgage is paid off, you really have an increase of 600,000. These things can be protected in a prenuptial agreement, but without them, best thing you can do is to keep your premarital asset in your own name. If you put it into joint names, it becomes a gift to the marriage, and depending on what county you live in Pennsylvania, will determine how much of that is going back to you and how much is going into the marital pot. But once it's put in joint names, it does become a marital asset. So you should talk to an attorney prior to getting married, maybe get a prenup, or at a minimum, if you don't, keep everything in your own name if you want to protect it.